This morning on the Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. Well, good to be here.
Pleasure to have you here as always. And let's get right to it. We're going up to the state of Minnesota. And this is a legal and legislative battle, Roger, that has been going on in that state. And that is, really for quite some time. But this is the property rights battle, in the state of Minnesota over deer farming and chronic wasting disease.
Yeah, that's right, Greg. It's been going on for about a decade, and it is a property rights matter, but it's a significant constitutional law matter, too, and that's why normally I wouldn't focus on a state-level case here in Kansas that's in Minnesota, but this one has significant ramifications, I think, for the ag industry as a whole, and I think we better pay attention to it. And in fact, later today at 8:30, I'm going to be talking about this on RFD TV. We've got more time to talk about it here, but it's that important. And the parties involved have asked the U.S. Supreme Court to take the case because they have lost it in the state courts. They've lost it in the Eighth Circuit. If the U.S. Supreme Court takes it, and I'll explain this as we unwind this, I'm not sure they win this case, but I think the broader implications are where do we go from here and what are the impacts on agriculture?
And in this case, what potentially could be the impacts on agriculture?
Well, what you had here is the attempt by the state of Minnesota to control chronic wasting disease. Now, yeah, that has a lot of problems. And can cause problems in the deer herd. And what you have are deer raising farms. So you have deer farms in Minnesota. And the state basically decided that we've got to keep the privately raised deer completely separate from the wild deer. And so they passed legislation earlier this year. It was Senate File 553, and that bill codified what I've never seen anything this stringent. I think it's the most stringent fencing requirements in the nation, and basically moving the state to a no-contact standard between wild and farm deer. And all registered farms must utilize exclusionary fencing. And some of the fencing requirements for a typical deer farm, it's going to cost them $200,000 to do this and get the permits, and they just can't do that economically. There's a double fencing requirement. The farmers, basically, deer farmers in Minnesota have four options as to how they comply with the new law. One is double fencing, create two separate 8-foot high fences spaced at least 4 feet apart, or have a secondary mesh fence with holes no larger than 2 by 4 inches attached to the primary fence with 12-inch spacers. Or another option is attach wood, tin, or dense shade cloth to the fence reaching a minimum height of 5 feet, or have a multi-strand 5,000-volt fence with a battery backup and an alarm system. Now, as I indicated, for many small farms, the estimates are that the cost of installing these systems can exceed $200,000, and that's cost prohibitive. And the law also introduced a notice of violation process. This is the administrative process as to how the state is going to ensure compliance. And if they find a deficiency, then farmers have a strict 14-day repair window. And if a defect allows for the possibility of entry or escape of deer, it has to be fixed immediately. Well, what you had here was the owner of a trophy whitetail operation, and he's become the central figure in his opposition to the statutory scheme and the overall opposition by the entire industry. He got a notice of violation in July of this year. He failed to install the mandated double fencing system, and he's claiming that his deer, and this is really the crux of it, Greg, he's claiming that his deer are livestock. And so the Department of Natural Resources in Minnesota, their wildlife-based rules contradict the Minnesota's Constitution protection for farmers. So we've got right to farm issues in here. We've got constitutional issues. But his refusal to comply due to the cost of compliance and the state's position of phasing out the industry triggered the registration revocation process, which is the death penalty for the deer farm. Now, you've got 14 days to fix the problem, as I indicated. And if it's not fixed, then the state can come in and revoke your registration and can issue you an order to depopulate the herd. And if you have a deer that would escape after that has happened, that's automatic grounds for seizure and destruction. The other thing here, Greg, about this law is it allows for a one-time transfer of your registration, which allows you to operate legally in the state of Minnesota to a family member. But that's it. Any subsequent change, you're done. So this is a phase-out of an industry by the legislature. They have deemed this that they don't want this, so they're going to self-extinguish the industry. So it's going to die out with the current generation of owners. And that's what this legal battle is all about. And what happened in late October was that the Minnesota Deer Farmers Association, after they lost in the 8th Circuit earlier this year, they have filed a petition with the U.S. Supreme Court asking the U.S. Supreme Court to hear the case. And the key question before the court is whether the right to pursue a chosen profession is a fundamental right that the 14th Amendment protects. And so if the Supreme Court declines to hear this case, which they may decline, then the DNR's no-contact regime will likely be the final chapter for Minnesota's deer farmers. If the court steps in, it could redefine the legal protections for small business owners and farmers nationwide against state regulatory wipeouts, as I call it. It's really a big deal with further implications for agriculture in general.
And in many cases, with this case being an example, that's creating tension between, state police power and the right to pursue an occupation, too.
That's right. We get into takings issues under the Fifth Amendment here. And normally we think of takings in the ordinary sense of where the state wants to come in and expand a road or take some land to create a park. We understand that they can do that, but they have to pay you for it. If they're going to take some of my farmland to expand a road, some type of interstate project, build a park, that's fine. But we saw this a number of years ago, Greg, from I-70 into Manhattan. That used to be a 2-lane road. It's a 4-lane road going in there now, and some of that land had to be taken from those ranchers on the south side of Manhattan, and they got paid for that. In fact, one of them got a road named after him. That was part of the condition that he was going to get. His access road was going to be named after his family. So the government has to pay you for it. They have to compensate you. They have to provide just compensation. And usually the battle in these types of situations is what is the level of that compensation.
And that's all a part of the Fifth Amendment?
Yeah, that's part of the Fifth Amendment of the state and the federal Constitution and the state Constitution. Well, here it's not they're not taking your property. So they're not coming in and physically taking this deer farmer's operation away from him. However, they're regulating him out of business. So it is, in effect, a de facto regulatory taking. The question is, in the case law, is how far can a state or federal government go in imposing regulations that fall short of a physical taking but constitute a regulatory taking that they then have to pay compensation to do that. Government has the right to take your property, but they have to pay you for it. That's going to be the question in this case. And there's a 1978 U.S. Supreme Court case. It's called Penn Central Transportation Company against New York City, where you've got a 3-part test for determining whether any particular action a state takes or a government agency takes, when that constitutes a physical taking. And they look at the economic impact on the owner, how much does the regulation impact your investment-backed expectations, and what's the character of the government action. And that's going to be at the center of this case. And I think he'll probably lose this case if the U.S. Supreme Court takes it. However, the broader agricultural community is watching this because it does test the limits of how much risk a state can use to justify the total elimination of a private industry. And here in Minnesota, they're talking about the risk of chronic wasting disease. Okay, this is based on what's known as a public policy, public trust argument. And I have spoken to groups before. I've written on this as to how bad, how pernicious this public trust argument can be. Very expansive. So if the government doesn't like a particular type of operation, and I think these niche-type operations would be most likely to be shut down first. But if they don't like environmental impacts of your operation, if they don't like certain type of nuisance-related impacts, this is really a way that the government can do an end run around right to farm laws. Every state's got a right to farm law. Kansas has one. But if they can weave in this public trust argument, then they can kind of backdoor their way around that right to farm argument and still wipe your operation out. So I think this is a very, very important case. It's a warning sign. So it suggests that if a state agency declares that certain farming practices are a public health threat, then the courts may not look very deeply into whether that particular science is settled before they allow the state to shut the industry down. So keep your eyes on this one. This is going to be a big one, and this is probably going to end up in my top 10 or at least my almost top 10 list of developments in 2025.
And keeping your antenna up on that, because if you're talking about livestock, you're talking about beef, pork, and poultry as well.
That's right, and I think those industries have to watch this particular argument. And this public trust argument is something I've been talking about for the last few years. I think given the change in the focus of government agencies coming out of the 24 election, that's kind of been pushed to the back burner. But it's out there, and it'll come back with a vengeance if the political winds change, because it is a political philosophy is what it is. And farmers and ranchers and rural landowners have got to be aware that that's out there in the background.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest. And, well, it is that time of year, Roger, end of the year, where we start to look at the year in review, eventually leading up into the top 10 of 2025, which we'll do in a couple of weeks. But I would think you'd have to start with the One Big Beautiful Bill Act and what it eventually will be doing here in 2026.
That's definitely going to be in my top 10 list. In fact, it may be number one. I haven't sorted through that list yet because I like to wait until the end of the year, because sometimes right at the end of the year there can be some significant things that come in. So I want to hold off on that. But definitely it's going to be in the list. Of course, the business-related provisions, 100% bonus depreciation that's already started, the ramp-up in expense method depreciation, that's huge, the retaining the QBI deduction, and just simply avoiding a massive tax increase that would have hit January 1. That was huge. And so those are very, very important things. And, of course, the commodity title of the One Big Beautiful Bill Act is in there. And at my tax schools that I do on behalf of K-State here in Kansas this past fall, we just concluded those last week. One of the things that we kept reminding practitioners is that you've got to be talking to your farm clients about how you're going to manage the income coming in next year. You're going to have SDRP that's going to dump into 2026 income. You've got bridge payments that are going to be in 2026 income. And then you've got the massive increase of the price supports that are going to come in October of 2026. So you need to have a plan in place now as to how you're going to handle all that additional income for your farm clients next year. And of course, if they have cattle, they're already sitting pretty with the cattle. So incomes look good. I had a lot of attorneys and CPAs that represent farmers telling me that they had a lot of happy farmer clients when I would talk with them at the tax schools. So, out in western Kansas, the rains were good. The yields were great. They haven't seen that for a long time. Yeah, prices are a little soft, but they can backstop that with cattle. So pretty good. But and massive changes in the crop insurance program. And, of course, Greg, we're waiting on the tariff decision. So that's going to be big. And if that drops in 2025, that may go to the top of the list because that's going to be a major opinion. But you're right. The One Big Beautiful Bill Act is huge.
Does your gut say that we could get that, and some that say we could get that tariff decision before the end of the year?
I think there's probably a 50-50 shot that we get it in the next 10 days or so. Otherwise, it'll drop, I think, in January. They're not going to sit on it longer than that. I can't see that.
Right. Well, another part of this is, of course, I don't know when the last time we didn't talk about WOTUS at the end of the year, but the proposed rule narrowing the WOTUS definition to line up with the Supreme Court Sackett v. EPA case, too.
Yeah, that's right. Both the EPA and the Corps of Engineers have proposed a significant revision to the definition of waters of the United States, and that rule is trying to align up with the narrower ruling of the Supreme Court in 2023 in Sackett versus EPA. And so that limits federal jurisdiction over wetlands or waters of the United States. They have to be relatively permanent waters. They have to have a continuous surface connection with a very narrow wet season requirement. So pretty good development in terms of what agriculture wanted out of that.
And then one thing that I think also continues to develop is the issues and potentially definitely legislation as well concerning foreign ownership.
Yeah, in 2025, we saw more developments on this issue at both the federal and the state level, and that's pretty important. And you got introduced to federal legislation. You had a number of states that are continuing to look at this as well as enact new laws. And just recently, the Florida statute, which was enacted a couple of years ago and immediately challenged, was upheld against a constitutional challenge. And so what we see in that is, I think, a guide for other states to follow, knowing that you've got some pretty good precedent there from a federal appellate court saying that one was structured correctly. It does not violate the Constitution in a number of areas. And so I think you're going to continue to see this as a big issue as we go forward for agriculture and rural land ownership as well as in other areas.
Because we continue to see the number of states enacting those laws continue to go up, too.
That's right. Yeah. We're over more than half of the states, and they're kind of really fine-tuning those. The legislatures will be revisiting those laws starting in January in their new sessions across the country and tweaking them a bit. And I would imagine there'll be tweaks to model it more closely after the Florida law.
And how much, just to use an example of Missouri and North Dakota with the air bases that they have, do they still need to tweak those, or are those pretty strong with regards to rural land near some of the air bases that they have?
They may revisit those, but the North Dakota one in particular has been tested, and they have made a couple of amendments already. Missouri is doing the same thing, too. But the issue with particularly ownership by the Chinese government of land that is close to a U.S. military base is a huge issue. And, of course, our legislature here has started to address that issue last year. And I think that'll be probably a larger focus going forward in state legislatures across the country.
Just as an example, like Whiteman Air Base in Missouri, and then you can look at Fort Riley and others that are in the state of Kansas, too. So
that's right.
All right, 2 weeks, top 10. That's always a lot of fun.
We'll have it.
To hear your thoughts as well.
We'll have it.
And if they want to learn more about the Minnesota case concerning the chronic wasting disease, that's posted on your blog already?
It's on my blog. It's up. It can be accessed through my website. I've sent that over to K-State. It's also going to be posted there, and it's on the free side of my Substack. This is one that I didn't hide behind a paywall on that one. So it's in multiple places.
All right. Sounds good. Roger, as always, appreciate it, and Merry Christmas to you and your family.
Well, Merry Christmas to you. Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.